Hi, I'm Charles, and I'm presenting on behalf of the Transportation Network Company unit at Washington State Department of Labor and Industries. I'm here to share with you details on the new rights for people who drive for rideshare companies. I want to thank you for taking the time to learn about your new rights and protections, and please feel free to visit our website at www.lni.wa.gov/TNC drivers for more information about these rights. Our goal is to provide an overview of the new rights and protections in the Minimum Wage Act that cover rideshare drivers. Only rideshare drivers who perform driving services for passengers are covered by the new statewide protections, so food and goods delivery drivers are not included. This presentation will also provide information on other key details and explain the resources available for drivers through the Driver Resource Center. Our contact information is listed at the end of this presentation. If you have any questions, let us hear from you. As of January 1st, 2023, rideshare drivers have the right to minimum compensation rates, paid sick time, workers' compensation, retaliation protection when exercising their rights under the law, as well as deactivation protections. These rights and protections fall under RCW 49.46.210, subsection 5, 49.46.300 through 350, and associated rules in WAC 296-128. You can find the RCWs and WACs on our website. For brevity, we will refer to transportation network companies as rideshare companies, as we often use these terms interchangeably throughout the department. To decide if these rights and protections cover you as a rideshare driver, there are a couple of distinct services you must perform in order to be considered a rideshare driver. 1. You transport passengers for a rideshare company. We need to be clear that these rights and protections do not cover drivers who deliver goods and services. Only rideshare drivers who transport passengers are included with these rights. You will need to be logged into a rideshare company's app or digital network in order to be considered a rideshare driver. 2. A driver is an individual who uses a personal vehicle to provide services for passengers matched through a commercial transportation services provider's digital network or software application. You do not have to work during a specific time period or certain amount of hours a week. 3. A driver is not an employee if the rideshare company does not schedule when, how often, or how much the driver works, if the rideshare company cannot terminate the contract of the driver for not accepting a trip, if the company cannot contractually prohibit drivers from performing work for other rideshare companies, if the driver is not contractually prohibited from working in any other lawful occupation or business. The Driver Resource Center, or DRC, is a nonprofit organization providing services to drivers that rideshare. The role of the DRC includes representing drivers during eligible deactivation appeals and providing culturally appropriate driver services, outreach, and education. LNI has contracted with the Drivers Union to operate the DRC for the tens of thousands of rideshare drivers statewide. If you are a driver who is deactivated by a rideshare company or have questions, please reach out to the DRC at 206-812-0829 to get more information on your appeal rights and representation. An account deactivation eligible for appeal is an action taken by a rideshare company against a driver for more than 3 consecutive days. These actions might include blocking or restricting access to a rideshare company driver platform, changing a driver's status from eligible to ineligible to provide rideshare services. Deactivations that are eligible for appeal do not include when there is a change in a driver's access or account status that is related to an allegation of discrimination, harassment, including sexual harassment, due to someone's membership in a protected class, or physical or sexual assault, or willful or knowing commitment of fraud, or related to an allegation that the driver was under the influence of drugs or alcohol, while a related active investigation that takes no longer than 10 business days is underway, or listed under any other categories established by the rideshare company and the Driver Resource Center as part of the agreement regarding the driver deactivation appeals process. LNI is not able to investigate deactivation complaints unless the allegation is for a deactivation as retaliation for exercising a protected right under the law. Again, drivers, please reach out to the DRC to get more information on your appeal rights and representation. Starting January 1st, rideshare drivers begin accruing at least 1 hour of earned paid sick time for every 40 hours of passenger platform time worked. They can begin using the paid sick time upon recording 90 hours of passenger platform time on a company's driver platform. This paid sick time may be used in 4-hour increments at a cap of 8 hours per day. You can also use multiple 4-hour increments consecutively. For each hour of earned paid sick time used, you must be paid at the rate of your average hourly compensation. These are the reasons you can use paid sick time: a driver mental or physical illness, injury, or health condition, to accommodate the driver's need for a medical diagnosis, care, or treatment of a mental or physical illness, injury, or health condition, a driver's need for preventative medical care, or to allow the driver to provide care for a family member for the same reasons.
Family member means a child, grandchild, grandparent, parent, sibling, or spouse of a driver. A family member also includes someone who regularly lives in the driver's home or has a relationship with the driver that creates an expectation that the driver care for the person and the person depends on the driver for care. Family member does not include someone who simply lives with the driver and has no expectation that the driver will care for them. A driver can also use paid sick time for the following reasons. When the driver has a child whose school or place of care is ordered closed by a public official for a health-related reason, or is closed after the declaration of an emergency by a local or state government or agency, or by the federal government. Absences that qualify for leave under the Domestic Violence Leave Act, during a deactivation or other status that prevents the driver from driving, to prepare for or participate in a judicial or administrative immigration proceeding for themselves or a family member.
As of January 1st, drivers are covered by workers' compensation during the time the driver is engaged in dispatch platform time and passenger platform time. If they are injured during that time, they can file a workers' compensation claim. Workers' compensation provides coverage while injured on the job after filing a claim with L&I. If the claim is approved, benefits can include medical care directly related to your covered injury, potential partial wage replacement, return to work help, and disability or pension payments for the severely injured. Rideshare companies will report and pay for workers' compensation coverage for their drivers during dispatch platform time and passenger platform time. Like any other business in Washington, a rideshare company can deduct a portion of the driver's wages to help offset the company's costs of the workers' compensation insurance. Rideshare companies may or may not choose to take the deduction. If you are injured while driving for a rideshare company, you should file a workers' compensation claim and inform your rideshare company of the injury. There are different ways to file a claim with L&I. You may tell the medical professional treating you to call toll-free 1-877-561-FILE, or you may file online at www.lni.wa.gov/file fast. An L&I claim manager may contact an injured driver who files a claim for additional information. The law also establishes minimum per mile, per minute, and per trip rates for drivers. On September 30th of each year, L&I will adjust these rates based on the rate of inflation. The new rates will take effect the following January 1st. You can also find the rate information online on the Transportation Network Drivers' Rights page in English and other languages. A rideshare company may not take any adverse action or retaliate against a driver who exercises their rights afforded by the law. The companies may not use the driver exercising their rights as a negative factor in any deactivation, restriction in account access, or other adverse action. The exercise of these rights may include right to paid sick time, compensation rights, tip and gratuity rights, right to reimbursements or other amounts due to the driver, right to utilize the Driver Resource Center, right to testify or intend to testify in any proceeding related to any driver's rights. It is unlawful for a rideshare company to interfere with, restrain, or deny the driver from exercising any of their rights. Adopt or enforce any policy that counts the use of paid sick time as time off the platform that may lead to or result in temporary or permanent deactivation, and take any adverse action against a driver because they intend to file a complaint or take private action against the company, institute or cause to be instituted by proceeding related to any rights under the law, or testify or intend to testify in any proceeding related to any rights under the law. As of January 1st, 2023, rideshare companies must provide each driver with a written notice of the rights established by this law to inform you of your rights. State law also requires rideshare companies to pay all tips to drivers. Tips are in addition to and may not count towards a driver's minimum compensation. You can file a complaint with L&I for the following reasons: minimum compensation, unauthorized deductions, tips and gratuities policy violations, paid sick time, reimbursement for tolls, fees, and surcharges, notice of rights, driver receipts, weekly trip notices, and retaliation. Information to include in your complaint should clearly state why you are filing a complaint and what rights you believe have been violated, provide any relevant information or documents that support your case. File your complaint within 3 years of when the violation occurred. For cases involving retaliation, you have 180 days to file your complaint. You can use these links on this slide to file a complaint. We have compiled other resources that you may review. Drivers with questions about their wage and hour, paid sick time, and retaliation rights can contact the Employment Standards Program by calling toll-free 1-866-219-7321 or sending an email to tncdriversupport@lni.wa.gov. Drivers who have questions regarding workers' compensation can contact L&I's Insurance Services Division by calling 360-902-5775 or emailing them at specialriskunit@lni.wa.gov. Customers can contact Employment Standards Access Coordinator for language access services. Our Employment Standards Program provides the following language access services at no cost. These services include phone and in-person interpretation, translations for documents during audits, consultations, and investigations. Customers can contact L&I's Civil Rights Program to report if L&I staff failed to provide language access services. L&I strives to ensure we comply with federal and state law and regulations related to civil rights and discrimination against national origin, race, color, language, sex, gender, religion, age, disability, and other protected classes. The information here explains how to file a discrimination complaint if you requested and have not received services in your preferred language, or if you feel that L&I has discriminated against you. You may also visit lni.wa.gov/civil rights for more information. We appreciate you watching this presentation by the Washington State Department of Labor and Industries. Any questions or comments can be directed to tncdriversupport@lni.wa.gov. On behalf of Labor and Industries, it's our goal to make sure you understand your new rights. Thank you and take care.